and gentlemen, ladies and gents, this is to update you on all of the happenings. You know that it has been 14 months since I pointed to the people about performance contracts, UCC Section 9 to 208. The surefire way to make a contract binding is through voluntary performance. Do you recall New Hampshire House Bill, now New Hampshire Law, Section 1778? It speaks about government and its deceptive contracts, their failure to inform, respecting their corporate offers to contract. The government agencies have performance contracts, unilateral contracts, whereby you and your conduct are bound by the contract. The first and most important is the court system and a plea granting the court jurisdiction, documenting your submitting to the court's jurisdiction. The incarceration contract and its first 3 pages highlight this. By actual case law I specifically found without looking to some document. The next is the DMV or other government agency's subscription through contractual application. Remember, your applying/subscribing is the nexus for jurisdiction. That is the word jurisdiction. Yap, the matrix reference. Oh, if you talk about the matrix, you are one of them. Yet we are talking about jurisdiction. The Supreme Court in 1824 stated that jurisdiction is that authority to act, the power to act. Without jurisdiction a party has no authority. Rhode Island versus Massachusetts. The Federal Arbitration Act is the jurisdiction, the contract, the parties, the arbitrator, the courts, and the government all derive their authority from the Federal Arbitration Act. FAA, when a contract contains an arbitration clause and evidences commerce and/or money of any kind. Can an unsigned contract be enforced upon a party? Yes, if that party has knowledge of the contract, and performs under the provision of the contract. Look only to New Hampshire House Bill 1778 under general purpose. It speaks to such contracts introduced by government, and this government organization, the state of New Hampshire's executive legislative branches, says that corporate government have failed to inform the sovereign people, the common community, of the consequences arising out of these corporate offers to contract. Then there is the restatement, 2nd, and 3rd, of contracts and the Uniform Commercial Code Article 9 to 208. This is proof of the general and fundamental principles of contract law. But wait, your contracts are bogus, gobbledygook, nonsensical, frivolous, meritless, some judges have claimed. Does the agreement contain a commerce clause, i.e., does it involve money? Does it have an arbitration clause? Then the court has no business even opening their mouth, as that is a matter to be decided solely by the arbitrator when delegated by the parties by the contract. Archer, U.S. Supreme Court, January 8, 2019. Did you know if the contract is challenged, as a whole, it must be decided by the arbitrator, not the courts? The Supreme Court continues to state this, and the courts ignore the Supreme Court of the United States. They are afraid of their courts being less crowded due to parties electing to arbitrate rather than going to court through a process that could take 20 years to complete. They are afraid of their power being shared by an arbitrator, so they attack the arbitration associations not of their own creation, where the arbitrator is not an attorney or an officer of the court. The arbitrator has the same power as a judge during an arbitration. Arbitrators are immune, so long as they follow the arbitration agreement and the FAA. So, the courts have been permitting arbitrators and arbitration associations to be sued despite their fundamental duty to dismiss the unconstitutional claims, which violate the most basic principles of due process and equal protection of laws. The Federal Arbitration Act says that the court must grant order to confirm arbitration awards. It says that the court must issue order to compel arbitration when applied for. The Arbitration Act has only provision for vacating an unusual award under 9 U.S.C. Sections 10 and 11, if the court does not find, by way of proof, that fraud has been committed by the parties, the arbitrator, or that the arbitrator committed misconduct, or that there's an obvious miscalculation in the amount awarded or the sanctions imposed, they cannot vacate. The courts assume, contrary to the FAA, that its rules respecting a motion to vacate apply. This view is an invented exception, for the Supreme Court in Archer has made clear that the courts must follow, not court rules, but the Federal Arbitration Act as written. Ibid. First sections 1 and 2 of 9 U.S.C., and there are a total of 48, divided into 3 sections of 16. The first 16, sections 1 through 16, apply to the arbitrations that contain an arbitration clause and commerce. Section 201 to 216 state arbitrations, yet if the state arbitration contains a commerce clause and involves money, then it is automatically federal, and sections 1 to 16 apply. You know, many state judges fail to apply the federal provisions when state arbitrations have a commercial element, i.e., involves money. Yep, no one has held them to account, but after this, watch and see how often state courts lose jurisdiction. The third and final section is also federal, but applied to international arbitrations, with or without a commerce clause. So section 1 says if the agreement has an arbitration clause, delegating arbitration to an arbitrator, then the FAA has sole jurisdiction, and rules to be followed are the FAA Act. The rules of the court, for that was the intent of Congress, the intent of the legislature. The Act prohibits the courts from claiming the contract is invalid, irrevocable, or non-binding. Only the arbitrator may make such a determination. Sections 1 and 2 mentions commerce. The Commerce Clause of the United States Constitution delegates Congress have sole jurisdiction over commerce, and they have written the FAA solely to handle contracts that contain both a commerce and arbitration clause. Yes, twice documents the congressional intent. Sections 3 and 4 deal with the compelling of the parties to arbitrate dispute that delegates such is to be done. Now the sections 5 through 8 deals specifically with arbitrators, their duties, and qualifications, which do not say that the arbitrator has to be approved by the courts, be an officer of the court, or an organization recognized by the court, established by its judges or its attorneys. Section 9 deals with confirmation, and the time frame for contesting an award, the default 1-year statute of limitations for how long an award may be confirmed after issuance. Yet it grants to the court statutory jurisdiction by stating the court must grant order to confirm. This is an obligatory duty, as the Supreme Court has stated, that there's nothing malleable about must grant. If none of the exceptions in sections 10 and 11 are proved, not by the judges, but by the opposing party, are present, then the judge has only one duty, and that is to confirm. Often parties do not know that the Act under Section 9 says the party contesting the award has only 90 days from receipt of the awarded to bring forth a challenge under Sections 10 and 11 only, for the Act provides at this stage no other avenue for challenging, contesting, or complaining. As you see, a party has plenty of time to raise an objection there originally when they received the notification of arbitration agreement, when they received notice of arbitration hearing, at the arbitration hearing. It is to be noted that some arbitrators conduct arbitration hearings the way a court conducts a no-party present hearing, de novo, solely based on documentary record. The Supreme Court has held that such hearings, as long as there is notice given prior, do not violate due process. So after so many opportunities to contest and the party going past the statutory 90-day limit, 9 U.S.C. Section 9, they are forever time-barred. The courts have been permitting time-barred parties to bring challenges after the statutory 90-day limitation. This is now a violation of the Act as written. The court must follow the Act as written, and the Act requires that the court follow the contract as written. Archer. People must appeal. They must challenge the court's ruling based on the court's failure to follow the Act as written, to challenge the court's jurisdiction. Now, I have created a document that purports to do just that, which highlights the court's inherent jurisdiction over arbitration, limited to the Act as written, and not Title 28 of the U.S. Code. The courts continue to treat arbitration as a lawsuit, when it is clearly not. There is no controversy, as the contracts containing an arbitration clause usually grant sole and exclusive jurisdiction to the arbitrator to hear any and all controversies/disputes, and the Supreme Court in Archer ruled that the court may only act when it is court business, and deciding controversies concerning arbitration is not the business of the courts. The courts have a habit of not minding their business when it comes to arbitration. They are highly jealous of arbitrators, as they are selfish. They do not wish an outsider to have their immunity as the Federal Act grants arbitrators who operates within the FAA, nor do they want the corporations they conduct commercial business to be adversely affected. However, they have no choice. Why? Because Congress intended the FAA to give the courts a mandate to confirm arbitration awards, to put private contracts on an equal footing, is why the Supreme Court in Rente Center v. Jackson, 2010, First Options of Chicago v. Kaplan, 1995, stated that the FAA was created to place a burden/jurisdiction on the courts to confirm arbitration awards. The courts suggest that it needs to be proved by some outside source, whisk. R of INS, 819 F sub at 800, Smith v. Rush Rental, CTRS, Inc. 360 F3D 504, 505, 5th Sir 2004. This is a lie, as the act created by Congress is the authority granting the court jurisdiction, an act the Supreme Court states, and I quote, "The act allows parties to agree that an arbitrator, rather than a court, will resolve threshold arbitrability questions as well as underlying merits disputes." Rente Center, 561 U.S. 63, 68-70, First Options, 514 U.S. 938, 943-944, 1995, when the courts make up a new rule that is not contained in the FAA, they are creating an exception. They are prohibited. Note, the Act, FAA, contains no exception, demanding one prove the courts have jurisdiction from an outside source, as Congress intended the Act to be self-contained. If this was not the case, the court would not need to say, "and we may not," engraft our own exception into the statutory text. See Archer, 556 US_____, 2019, quoting ExxonMobil Corp. v. Lapida Services Incorporated, 545 U.S. 546, 556-557, 2005. Do you get it? If a party had to rely on separate rules and statutes, Congress would have stated so. They would have stated the other laws that were applicable. Rules of civil procedure apply, but only limited to their reference by the Act. For note, if the rules of civil procedures, which are added, amended, and/or subject to revision, were to be generally applied, then the courts could create endless exceptions, thus engrafting the Act to suit their will and not the parties. The exception is inconsistent with the statutory text and air precedent. The courts must respect the party's decision as embodied in the contract. We must interpret the Act as written, and the Act in turn requires that we interpret the contract written. A court may not override the contract. A court possesses no power to decide the arbitrability issue. The court has no business weighing the merits of the grievance, because the agreement is to submit all grievance to arbitration, not merely those which the court deems meritorious. Steel Workers, 363 U.S. 564, 568, 1960. The courts know that Sections 3 of the FAA, 9 U.S.C. Section 3, provides that a court must stay litigation. This quote from Archer provides a definitive stand-your-ground positions on two issues. 1. That the court must is a jurisdictional and delegatory provision, and 2. A court must stay litigation proves that arbitration is not litigation, and the rules of litigation, the fees for litigation, are inapplicable. What has been happening is that the courts have been charging individuals the fee for a civil litigation action, when the motion to compel arbitration, motion to confirm arbitration award, motion to vacate, as prescribed by the Federal Arbitration Act, are all governed by the FAA, exclusively. Neither requires the parties follow a separate statute, set of rules, or provide proof of outside the scope of the Act. Now many will want to go demanding the court do this or that to correct the record. You can do that if you like and waste both the court's time and your own, or you can simply understand you can do a motion to correct the record, but title it Motion to Vacate due to lack of jurisdiction, Motion to Reconsider and to challenge jurisdiction. On the issue of the contracts, can you have a contract that is based on a template? Yes. Look at how all corporations use the same contract for all their customers, clients, etc. When the names of the parties are added, it becomes a unique document. For instance, all birth certificates for the state say the something, but when parties' names are added, it becomes a unique agreement. Can a contract have the parties agreeing that the earth is flat, Columbus discovered America, that the moon is a planet, that a dog is a cat, that God does not exist? Yes, the parties can agree to anything. It is a contract requiring a party do the impossible, not agreeing to the impossible, that makes it invalid. For instance, a party cannot agree to turn water into gold, as that is impossible, as the two are made from completely different elements. Some would argue this point, and if you are among that group, then contracts, arbitration, and the courts should be avoided at all costs. You will only cause injury to yourself and others. What makes a contract binding, valid, and irrevocable? Well, I shall deal with unilateral contracts. Here are the basic and required elements. 1. At least two parties, with knowledge/notice of the agreement. 2. That the agreement is doable, workable. 3. The agreement has a completion or expiration clause or date. 4. That there is consideration/value in the agreement. 5. For the sake of FAA, an arbitration clause. 6. That the parties performed under terms of agreement. Now some will say, look, your contract says, and it states, does it matter what the contract says? For the sake of law, no. As long as it is agreed upon by the parties, it is doable. Only the parties are affected. It does not affect the public policy, as it is a private agreement. Now if it has a provision that does affect the after-mentioned, then it does matter. Background: on or about March 16, 2018, I was contacted by D. Hawkins, who was a party to the first incarceration contract containing an arbitration agreement. Congress was petitioned and a private law passed, but not enacted, whereby Congress determined that the incarceration contract was binding upon the parties and the United States. Why was this significant? In 1925, Congress passed and President Coolidge signed the Federal Arbitration Act. The courts cannot overturn the act enacted by Congress and signed by the President. When Congress held that the contract was valid, Congress had retrofitted that stance by overcoming a presidential veto with a 2/3 majority. The private law is now removed from the record as a national security matter, despite no such claims as recorded phone calls to the government printing office and Rand Paul's office. Rand sponsored the bill, document. So for over 22 months, I have made arbitration my main focus, and because arbitration has been around from the beginning, over 6,000 years, the FAA is not the authority, yet in the U.S. Congress has provided strict regulations under the Commerce Clause. The issue was how to help the common folk, the common man, and how to apply the provisions of the Act to access redress. The government, through its employees, departments, agencies, officers, agents, etc., has been utilizing arbitration to their advantage, even having arbitration associations. After 8 continuous months, it was realized that there is no Federal Arbitration Act restriction on an arbitration association, or neutral, or arbitrator. So I founded an arbitration association, yet I have participated in no arbitration as an arbitrator, could not discuss my personal matters as to protect the integrity of the arbitration process. It was anticipated that the American Bar Association's Arbitration Association, AAA, would challenge the arbitration association I founded. It was anticipated the judges' arbitration would challenge the arbitration association I founded, and true to their interfering nature, JAM, judges, did use its influence to interfere with our revenue to operate. Although the association only acts as process server, has no employees, only appoints neutrals, who are not related to the agreement to act as arbitrators, so that there is no issue of fraud and misconduct, these organizations, Federal Reserve, FORUM, JAM, AAA, and others, have attacked us. The courts have made no quorums about saying it is going specifically after SAA, the Sitcom Arbitration Association, so we highlighted that the association only serves documents on parties, so they went after our bank accounts, merchant accounts, PayPal, and others, closing over 7 business accounts in a 3-month period. Why? So that they could make it seem like the association was not well organized, and not well functioning. We have an arbitration agreement on our site, which has these parties agreeing to be bound by said agreement. They finally read the agreement and have hacked our websites over 6 times, deleting over 40 GB of documents, changing links to direct people to JAM. And as Morpheus said, we are still here. Now, some have attempted to introduce their own contracts, without including an arbitration clause. One such contract came my way. The party, after paying $500, failed to provide a copy of the contract, which included an arbitration clause. The arbitration was stayed for 10 days until he could provide a copy of what we asked for more than a month. People, it is your responsibility to make sure you dot your I's and cross your T's, so to speak. The contract with an arbitration and commerce clause are the absolute necessities, and without this, the arbitrator has no authority, absolutely none. Most of the arbitration that come our way are defaulted agreements, where the opposing party chooses not to participate or respond, and these are the no-brainers. As to the contract, once proof of performance and service is satisfied, this proves to the arbitrator one option, to issue judgment in favor of non-defaulting party. So knowing that the agents of AAA, JAM, FORUM, and others would attack, I decided to do an agreement with the California Department of Corrections, and in that agreement included a double default provision that permits habeas corpus by arbitrator that is binding on all parties. The state of California has defaulted. Look, as stated, now people will start adding arbitrations to plea agreements and habeas corpus provisions to contracts. They will try to change the system, the FAA, but for those whose contracts are complete and served on the opposing party, they are grandfathered in. They have gone after those who utilize contracts with government agencies, attempting to scare them with claims of fraud. The people do not know that claims of fraud must be proven. You just can't say, he/she committed fraud. All of the elements of fraud must be present. By the way, when the opposing party does a motion to vacate, you do a countersuit demanding a jury trial, and do a demurrer. People will say, I do not know how to do a motion for a jury trial. All you do is get a civil motion template, fill it out as best you can, follow the format of the civil suit/complaint, with the parties' names beginning the same. You can add the judge's name to the list of parties, as once a judge acts outside their jurisdiction they lose their immunity. Failing to follow the FAA or assuming the duties of the arbitrator, by saying the contract as a whole is invalid, or the arbitration clause and/or the contracts were never served upon the parties, are not the court's business. The judge is not protected by judicial immunity. The title of your motion will be counterclaim/countersuit, motion for reconsideration, trial by jury demand. As your contract should have a tort option clause, so that you can bring such a suit after an award or breach is documented. People ask, what if the judge levies sanctions against me? You must do the motion for reconsideration and challenge the court's jurisdiction. By doing so you bring forth legal challenges and federal questions, and, when the judge denies you, as they will, due to hostility towards arbitration, as noted by Congress, You will then appeal, raising all of the points you brought forth in your motion for reconsideration and challenge to the court's jurisdiction. Look, they have everyone and everything figured out. They threaten you, you panic, get scared, and you react. You cannot react, you have to be prepared to act, plan ahead. As stated, the jurisdiction is Title 9 of the U.S. Code, not Title 1, 28, 42, 7, or 14, Title 9. That is the boundary that has been marked out by statute. Make them play within, between the lines. The courts have planned that you will not appeal the bogus orders, because you do not understand the rules. Okay, first, the appeal for all matters concerning arbitration is the only provision where the rules of the court may apply. Read Title 9 U.S.C. Section 16. How do you file an appeal? First, you file the motion for reconsideration, then after the court denies you, you file a notice of appeal. The body only has to say notice of appeal, and you signed and dated? Yes, a motion that only needs 6 words. On appeal, you focus on challenging the court's jurisdiction, by stating the something contained in the motion for reconsideration and challenge to the court's jurisdiction, telling the appeals court that the trial court erred by failing to follow the FAA as written, failing to maintain FAA jurisdiction. That there is only one statute that applies to federal arbitration, and that is the FAA. The courts have no latitude to create exceptions, reasons for denying request, that are not listed in Section 10 or 11 of the Act. You explain to the appeals court that the trial court's judgment must be vacated, and the matter returned to that court with instructions to proceed within the confines of the FAA. We have created a reconsideration and challenge template. It is attached to the site SAAlimited.com. Feel free to utilize this document that has been designed to kill the presumptions of the attorneys whose attempt to change the subject. Do you not see? They have nothing. They cannot say that they did not get notice. They cannot say that the contract does not contain a valid arbitration clause. They cannot say that the FAA does not apply. Dispute the fact they cannot say these things. They will attempt to while you argue with their presumptions. People in arbitration, they must prove. The burden is on them. Do not allow them to switch to you. At this time, these agencies, attorneys, and judges are all attempting to overwhelm, by filing document after document and suit after suit. First, the contract prohibits. Second, they are not only time-barred as a result of the 10 to 20 calendar day statute of limitations embedded in the contract, and the 90 days to contest the award. It is called res judicata, which simply means that if you have a judgment from one court, you cannot go to another court of similar jurisdiction to obtain a different judgment. An appeals court is not similar jurisdiction. The arbitrator and judge have the same power and immunity under law. So if a party refuses to respond, while having a duty to respond, after receiving notification, they are in default and/or breach of contract. If after receiving a notice of arbitration hearing, they still choose not to participate, or after receiving an award, waits more than 90 days to contest, per the FAA they are forever time-barred, estopped, must accept their fate at the hands of the record. You must read New Hampshire Bill 1778 of March 2018, of how they document that government does compelled performance, contract. This means that it is not as voluntary as it seems. Yet you first apply, then you perform. Your contracts are nothing short of the same. The agencies, membered banks of the Federal Reserve, creditors all have a prior relationship. They by your prior relationship must respond to your questions of redress, verification of debt. Verification requires under penalty of perjury, statement, under the Fair Debt Collections Procedures Act FDCPA. You can pose questions in the form of proof of claim, show of cause, and you can have them agree to the terms if they fail to respond with specificity. You have equal protection and due process in your favor. Now if your contract is invalid, and they will claim such is the case, they will never specifically say why, only a vague, general response. There is one huge problem. The FAA says in such instances only the arbitrator may make such a determination. They will say you need to prove this or that. The FAA says you have to provide 1. A copy of the contract with arbitration and commerce clause, 2. Motion to compel arbitration, if you seek under 9 U.S.C. sections 3, 4, 3. Motion to confirm award, under 9 U.S.C. section 9, 4. Memorandum of laws, on internet regarding arbitration confirmation, 5. An order for the judge to sign 6. Proof of notices, of contract, of fault, of default, of arbitration hearing and of arbitration award. These things are necessary. You do not by the FAA, have to prove anything once you have supplied the above. If you are asked to prove this or that, ask what provision of the FAA requires you to do so. If the other side is challenging the award and are within the 90-day statute of limitations, then you must stand your ground. Do not get distracted. Focus on the requirements of the Act and your compliance with this contract and the FAA. Congress created the FAA to overcome judicial hostility towards confirming arbitration agreements, to put them on the same footing with other contracts. Arbitration is if the parties agree, a non-judicial process. The Supreme Court stated this in Archer, 2019. They say that the parties may choose to have their dispute resolved by arbitration rather than a court, and when that is the case, the court must accept the choice of the parties as stipulated in the agreement. Rent-A Center, 2010, Archer, 2019. Some are intimidated and scared. The contract will usually include a retaliation, clause, and they can be held civilly liable for violating this provision as a third party. Remember, an arbitrator, nor judge, or government employees have any immunity when they act contrary to their delegated authority. When arbitration and commerce contracts are involved, the authority comes from the contract first, then the FAA. When they act contrary to law, they waive immunity. Remember, every contract with the government that has an arbitration clause and a commerce clause, government willfully abandons its sovereign capacity, and are to be treated as mere mortals. See Clearfield Doctrine. Do you not see any FAA contracts with government? They can have no immunity, as it by law as written involves commerce. Again, the courts have only the jurisdiction mapped out in the FAA. Even if the court could somehow stay the appeal, it possesses no delegation of constitutional authority to dismiss the appeal without due process of law, of the land. This court is accused further of denying 1. The due process rights to appeal, to a speedy disposition or appeal, the right to challenge the court's jurisdiction. So, I decided to accept the attempt to change the terms and conditions, by doing a conditional acceptance of agreement. The new agreement was sent to the First Circuit Court of Appeals, the Administrative Office of U.S. Courts, the U.S. Attorney General as representative of the United States, ETAL, supplying proof of the government may enter into commercial agreements the same as a private person, and that by entering into such a commercial agreement, these parties did so waiving any and all claims to immunity. Everyone, the law is founded/based upon principles. Arbitrators derive their authority to resolve disputes only because the parties have agreed in advance to submit such grievances to arbitration. AT&T COMMV Communc NS, 475 U.S. 643, 648 to 649, 1996. Because the plaintiff's offer clearly provides a mechanism for rejecting plaintiff's offer. Thus, respondents had a reasonable opportunity to reject plaintiff's offer. By defaulting on their obligation to respond, as respondents had a duty to respond, the default, although willfully constituted assent per terms of the agreement, the respondent's conduct is not actual silence. Silence constitutes acceptance, emphasis added. Hill v. Gateway 2000 Inc., 105 F. 3rd 1147 to 1149, 7th Sir 1997. As the court noted in Gateway, the Hills admitted to receiving the form contract, but failed to read it. Where a letter is properly addressed and mailed, there is a presumption that it reached its intended destination in usual time and was actually received by the person to whom it was addressed. Hainer v. United States, 286 U.S. 427, 430, 76 L. ed. 861, 52 S.ct. 417, 1932, the court must presume that a letter properly addressed was received. Gadfrey, 997 F.2 ND 335, 338, 7th Sir 1993. The reason for that is because the U.S. guarantees the delivery of the mail, through rain, snow, sleet, and hail. Many are not getting the Federal Arbitration Act. It is an outline, the rules, and procedures that are embedded within the text, which is why the Supreme Court states, we must interpret the Act as written. Many an attempt by clueless learned fellows of admission have thought that they could go to the court to seek an injunction against an arbitration award. Not so fast. That is not an option under 9 U.S.C. Section 9, 10, or 11. When you do a motion to confirm, the only defenses are in 10 and 11. You do not believe me, go and reread Section 9, which states that the only exception to the court must grant, confirm award, is the exceptions listed in Section 10 and 11. Again, if they claim fraud, fraud must be proved and the burden per the FAA is on the defendant. So stop thinking you have to defend yourself. You can write a motion letting the court know that the option to issue an injunction is only provided under Section 16 of the FAA, as the limits placed in Sections 9 through 11 do not include challenge to bogus, nonsensical, unintelligible, or word soup-laced contracts. A contract may not be challenged under 9 U.S.C. Section 9 unless it is through arbitration, procured by fraud that is proved by evidence, there is obvious misconduct or an obvious miscalculation that appears on the face of the document. These are the limits the court is stuck to being confined. No further movement is provided under 9 U.S.C. Sections 9, 10, or 11. So if a challenge is made to the award during a petition to confirm, you must then let the court know, not by insisting, but by stating clearly, that the court possess no jurisdiction for making such or considering such, as the exception or the avenue for such a request is only reserved at Section 16 of the Act, and even within the constraints of the Act's Sections 1 to 15. You must challenge the court's jurisdiction without being confrontational, and yes, they will be confrontational. So, just make your request explain that the governing rules are the FAA, and the rules of the court only apply under a limited provisional set of the FAA, yet not under Section 1, 2, 7, 9, 10, 11. So, if the court refuses to follow the Act as written, and that was in effect the date of issuance of award, then I have no choice but to challenge the court's jurisdiction. Remember, no one can get upset for your exercise of a right. If they do, just say, I put you on notice that you are interfering with my free exercise of a secure right, you are in violation of your oath of office, I must ask you to cease and desist, and any further breach of agreement will result in contract provisions being strictly applied. Many of you are scared of the courts, afraid to challenge the jurisdiction, because you are not sure of what will happen. Well, by law, jurisdiction may be challenged at any time, and jurisdiction, once challenged, it must be proved to exist. All of the courts know this, and most will ignore your challenge. If they do, by law they are without jurisdiction. That means that when the court fails to provide its jurisdiction, it has none until it proves it. Now, I did not make this up. Rhode Island v. Mass, 37 U.S. 657, 1838. If you challenge a court's jurisdiction, what is the worst that could happen? You are thrown in jail, they take away your right to ever challenge again, they revoke your YouTube access, or, they ignore you and you get to use such a violation on appeal? They are more worried than ever because people can utilize contracts to compel performance of government agencies, such as prisons, and why not? The contracts worked as plea agreements, whereby you agree that what they did was legal, lawful, and right, yet only if they can prove it by certain claims and documentations. Now we have Supreme Court stating that in the first instance, that should have been the only issue. Could the court order a party to arbitrate, compel, when the contract clearly did not delegate such authority to an arbitrator? Now Archer and Whitesats did not stop there. They opened a door for all of us. They argued that the dispute was not subject to arbitration because the complaint sought injunctive relief. People, do you see? Injunctive relief is for an arbitration to decide. Read the syllabus. It is right there. So all of you, who have attorneys asking for vacating of an award, outside the exception of the FAA, or who seek declaratory injunctive relief, the Supreme Court of the United States, SCOTUS, has stated that a party to an arbitration contract that has delegated all disputes to be resolved by arbitration, that it is not the business of the courts to interfere. Injunctive and declaratory relief is a question of arbitrability, not a federal, legal, or judicial question. The courts may not override, overrule, and/or decide any issue concerning challenges to the contract as a whole, or to arbitrability. They simply have no power, no authority, and no go_damn business messing with the arbitrator's business, that the courts must mind their own business. On the jet fuel dump, what was not said? Delta airline pilot dumped jet fuel on a populated area, not by mistake. He was not lost, he knew his altitude, and he got permission. People, since 911, do you for a moment think such would be a violation of the Patriot Act, EPA? The FAA rules do not permit. Has the pilot been suspended or fired? I just have questions. Why would they do this? Wrong question, the wrong angle. Everyone should read the hazard label at the gas pump. The next time you are pumping gas, you will see that the fumes have been documented as cancer-causing. The people were deliberately poisoned. That is what the suit should be about, as these hazards are listed on the plane, as well as the truck, the storage tank. They all warn of expert exposure. Was the exposure long enough? Who can determine such? So a class action will be next, and discovery, depositions, policy review, charges, firing of plane personnel, flight crew. Yeah, let's see if those people get some payback for not respecting their lives. It's about more than just school kids, these were whole neighborhoods. Mothers for housing. Mothers, I am sorry, you were onto something. However, you failed to create a bill, so all of the work you did on the house, from sweeping, to nails in wood, to gardening, you document. Find the code, enforcement code, that speaks to keeping property clean, grass cut, trash cleared, neighborhood beautification, and then sends bill to the company that evicted you. As by law, you can make your own claim and be reasonable. You should file a lien on that property, proof of work, proof of mailing bill, any pictures you have documenting your work. Give them 30 days to pay. Also charge them for moving expenses, as they were to pay outstanding debt prior to eviction. You did the work and could prove it. They don't get to win just because you say so. Now, mothers for housing, pay attention. The proper way to do adverse possession. First, you must understand the purpose, original, for adverse possession. It was during the time the United States was formed, a lot of free open land, and they needed people to inhabit that land. Remember the gold rush, the Hidalgo Treaty? In both instances, people would go squat on land, put up for post in four corners staking their claim. Adverse possession lawful. Modern day adverse possession, a great deal of misinformation out there. Each state has statutes on adverse possession, some 1 to 5 years, others greater than 20 years to get title. There's a much more simple way. Let's outline it. Do your research. Do not go and ask an attorney, can I do that? He by law cannot tell you. His response will be quickly, no. You find an abandoned property. You do a quick observation of the property, making sure it is truly abandoned. no electricity, no furniture, that the yard is unkempt, trash, weeds, junk, and you start to clear away trash, junk, weeds, yes, a job, not all in one day. You have a right per code, city and county code on sanitation, trash, infestation, clutter, fire hazard, etc., to assist government maintain a habitable state. You use phone to take pictures before and after. And you post a bill at the front door, or mail to property, metered mail, keep copy of receipt, property owner, addressed to not occupant. The following week you do the same thing. You continue your beautification program. Feel free to plant flowers, paint, but you may not enter property just yet. Also, do not show up in just some car, it should look like a work vehicle, there should be a business sign, business card, garden tools, at least 3 people, labor cost is to be placed on bill, fees must be reasonable, similar to the going rate for like services. You will send this property 4 bills, over 4 weeks, taking before and after pictures each time, for your proof and records only. You will, for the sake of the law, send a second letter to the same property address to yourself, doing a change of address with the post office, for yourself only. The 3 people, associates, should be present assisting you. So that no one can claim you are doing something illegal, you must have a copy of the city, county, and state codes for up the keep of properties, yards, infestations, etc. Now you are at the 4th week, you have gone to Home Depot or Lowe's and gotten locks for the doors. Now you can, after mail is received the 4th week, in your name, enter the property, as the law says as long as you receive mail there and can prove it, the owner must use the court to evict, you have a presumptive right to be there. You by now get the electric turned on in your name, the water, trash, cable. Documenting all cost, work, and now, the 4th week is complete. You send a debt collection default notice, the labor documenting hourly fee not more than $60 per hour, plus equipment rental, hourly, Home Depot has pricing, yours should be 15% more only, overtime, weekend fee surcharge, garbage disposal, supplies, do you now understand? Slow down, many have gotten ahead of themselves. Remember that this is a job. So you are not doing this for a home but to keep the area, neighborhood clean, safe, and habitable. That is why you do everything by the book. Do not skip a step. Now, that you have sent the default letter, to the owner, property owner, at the last known address, include a copy of all previous bills with debt collection notice, download script on debt collection, that complies, this is an attempt to collect a debt script, with the FAA. You will receive a knock at the door, a public officer from the police department. He will claim that you are trespassing, this is why you waited the 4 weeks, did the work, created the bills, keep copies, sent by mail, proof of mailing, utility bills, all get presumption of residency. They will have no choice but to attempt to convince you that you can and will go to jail if you do not leave. You will simply reply, not according to the law. I have provided proof of residency. Now, if you are evicting me, where is the court order? Why did I not get a hearing before a judge? If they keep insisting, ask for a watch commander. Do not argue. Do not answer irrelevant questions. Now the court is involved, you will put your bill, state laws, pictures, and proof of mailing to the property owner's last known address, as your counterclaim. Before they can evict they must, by law, pay the reasonable portion of the bill. You just cannot go and occupy a property, Mothers for Housing did not mess up. They did not bill the property owner. They need to sue for unlawful eviction, and failure to offset debt. But how do I get a home? This only shows me how to state a company. This is why you look for a property that is truly abandoned, because after 2 months of billing the owner, you will go to court and do a writ of possession for the property due to the debt. You must place a lien on the property, but you must follow the rules and attached bills, Current with totals bills should document possibility of interest being charged after 30 days of non-payment, and 20% per day thereafter. If the property is truly abandoned, when you go to court, you by now have pulled a copy of the title to the property. You will have to serve the person name. You are not required to do this until after you have repeatedly mailed to the last known, to you, address, which is the property address, which is why you mailed it, property owner, and not a named person. The same as coupon company's junk mail is sent to property owner, on the title, to the property owner, occupant, or resident and the person named on the title at address of property and to person named on the title at the address, mail to address, on title. Most time after service, follow rules of proof of service, just you have to do your homework. This is not free, was never to be free. If you do the work, documenting everything, you will win. At the very least you will be reimbursed. The party does not show up, or they default and the clerk issues judgment for writ of possession of property. If the party shows, then you have your debt, proof of non-responding to bills, letters, not keeping property up to code, which is the issue. The usual way of adverse possession, you can only do one home as everyone has the right to one home, adverse possession, and usually permits a person to adverse possession only one home, as it normally requires one to be in the home for years continuously. However, you cannot occupy 2, 3, 8 homes at one time through adverse possession. Some have thought, wait, that means that Donald Trump, for example only, cannot own more than one home, so I will go and adverse possession his vacation home. Oh, hell no. You cannot do that. Adverse possession does not work that way, the law does not work that way, and life does not work that way. However, you can beautify the community. Keep the property free from debris, vermin, pests/rodent through documented pest control, fire hazard control, repair, upkeep, etc. According to the code, that you have looked up or called to ask where is the code located for the city, county, state, there are more than one code enforcement agencies that require property upkeep, that property be free of debris, trash, rodents, weeds, and overgrowth. Eventually they will stop answering your questions. They will start asking you questions, like why do you want or need to know? Many will get stupid, many of you will get attitude. For what? Simply say, I am just asking as a citizen of the state, and by law you are required to direct me to this information. They will direct you to some website, or building. Your reply is undisabled and I do not have the internet available at this time. Wait, what is your disability? What is any disability? Why does my disability matter? Are you attempting to use my disability to deny me services in violation of the ADA? Well, everybody has access to the internet. Are you calling me a liar? Let me speak to a supervisor. I need to file a complaint for discrimination and follow through. If you have to file a complaint, file a staff complaint, grievance. If you have to file an appeal, administrative, and then file an appeal. None of this is complicated. It only appears that way because you are unfamiliar. So as you follow through, you pull up rules, go to YouTube, and watch videos on the process. Look, I'm doing all I can to help the many, all I can to prove, arbitration as it is law today, is the only feasible way out. It is streamlined and quick. For instance, the courts have said that the redemption coupon contract is just a piece of paper, junk. They do not get to do that. The coupon has value and consideration built in it, does an assignment of interest, parties have a prior relationship, it involves commerce, book entry credits, has an arbitration clause, is between competent adults, and is doable/workable. This is what gives the contract value. Whose job is it to make such a determination? You will say the arbitrator, but it is the parties. As long and so long as the parties have agreed, the contract is valid, irrevocable, and enforceable, unless one of the limited exceptions of 9 U.S.C. Section 10 and 11. Get familiar with that section, take it extremely literal, as written, and the arbitrator will settle any controversy between the parties respecting the agreement. Please go over this information until you understand it. Yes, over and over again, that is for your benefit, not mine. I say show me anyone who understands the FAA and performance contracts better than I do, and I will show you a liar, a fraud, an idiot, for there is no one alive. Have a good day.